Hello, everyone. So the first topic that we're going to be talking about is going to be termination clauses. We're going to do a rundown of everything that is important, and we will have a Q&A that is at the end. Briefly, Ashkar Law is a firm that's been operating for 10 years now. About 30% of what we do is corporate commercial litigation, but 70% of what we do is labor, employment, and human rights. So litigating termination clauses and contract disputes is something we do on a regular basis. Your presenters today will be, well, one of us is good looking and the other one is me. So Clifford's joining us. Clifford is a partner here. He's solid all the way around. So he's going to be going through the cases themselves, and I'll be highlighting some important issues that one should keep in mind when it comes to termination clauses and rolling them out and everything surrounding what termination clauses entail, the dangers of not having them drafted properly, and the benefits that you get when it comes to peace of mind when you have them rolled out properly, drafted properly, and have your managers trained on what to look for when they're giving the contracts to employees. Let's jump right into it. Termination clauses keep failing. And I often say on these webinars, if you've joined one before that I've presented, if the courts are clear about what is an enforceable clause and what's not an enforceable clause, probably 50% of employment lawyers wouldn't have a job. It would be nice to have that clarity from the courts, but none of these cases are getting to the Supreme Court to determine what is the correct verbiage of termination clauses and what is acceptable and what's not. It's a bit of a cat and mouse that keeps happening, but some of the general information that is equally applicable to everything, every contract before and moving forward, that courts always assume that employers are the more sophisticated party in the transaction. The rule of contra preferentum is applied, meaning the contract is interpreted against the drafter. That means if you, as an employer, give a contract to an employee, the court's going to side with the most favorable interpretation for that employee. Many employers want to have details in the contract may render it a bit confusing and vague. A good precaution that we always give our employer clients are to have as many certainties in the termination clause and to avoid anything that is vague. It is to use simple language as much as possible and to reduce the language that could be interpreted in different ways. So if you have two parts of a clause that are conflicting each other, then the most favorable one to the employee is what is going to be upheld by a court. So we always want to push for a simple termination clause. But, if you look at your contracts, many times these termination clauses are a whole page or half a page, thinking that the employer is doing something better by clarifying different situations that one, for example, could be terminated for cause. But we found that the more details one puts in and the more vaguely a term could be interpreted, the worse it is for the employer. Moving to the next slide, we will talk about how are termination clauses interpreted. Termination clauses aren't looked at as a sentence in the void. It is looked at in the context of everything else that it has. So whether we talk about the benefits and the termination, what happens to the benefit after termination, and what happens to accrued vacation pay, for example. All these, the court will look at a holistic approach when it comes to interpreting them. So avoiding contradictory statements or phrases in there is extremely important. Another example of the contradictions that happen many times is an employment termination clause will often have what happens when it comes to without cause termination, meaning terminating someone for no real reason or for a business reason or restructuring, for example, versus just cause. When someone, for example, punches someone across the face or steals, if a just cause part is vague or unenforceable, that will render the entire termination clause unenforceable. And a bit worse than that, it's not just the termination clause for cause, without cause that is taken into account, it's the entire agreement. And that's why often, if you look at your agreements that you hand out, At the bottom of them, they'll have a severability clause, meaning if one clause in the agreement is unenforceable, then that doesn't render the entire contract unenforceable. Or an entire agreement clause, meaning anything that you tell an employee before hiring them or what's in an offer letter should not be taken as part of the agreement. And the document itself, the contract, is the entire agreement there. So always assume that your contracts are going to be looked at in the most negative way possible and judged as harshly as possible. And it's always better to be conservative and to be sort of defensive and clear as opposed to being and valuing more flexibility in an employment contract. Next part that we will discuss will be how does the court look at the termination clause when it comes to case law, and how do cases that get in front of a judge, how do they get evaluated? The major reason that a contract is deemed unenforceable, firstly, is the termination clause. And second is because it fails at providing the employees with the Employment Standards Act entitlement. The Employment Standards Act entitlements are the absolute minimum that an employer can give an employee. Often I'll be speaking with employers who say, well, Chris, I offered them, 2 weeks. That's what the contract says. Why are they not agreeing? Well, it's because the contract says you will never get less than the Employment Standards Act, but it doesn't remove the entitlements to common law, for example. And briefly put, the Employment Standards Act provides two types of termination packages. The termination pay, that's 1 week per year up to a maximum of 8 weeks. But then if an employee has been employed for 5 years and the company has a 2.5 million payroll, or the company is terminating 50 employees at a time, then that employee is also entitled to what's known as a severance pay. And colloquially, everyone uses the word, do I get a severance after working a year or two? You get termination pay, potentially, but not severance pay. But if someone works more than 5 years, then they'll get the termination pay 1 week per year up to a maximum of 8. And on top of that, they'll get the severance pay, which is 1 week per year up to a maximum of 26 weeks. It adds up quite quickly. And that is, unfortunately for employers, that's the absolute bottom line that an employee should be getting if they're terminated. The risk is that things get interpreted that someone will get a certain amount. And if that amount ever falls in any situation under the Employment Standards Act, then the contract will be deemed unenforceable and employers will be on the hook for common law notice. Common law notice, briefly, is a calculation that considers how old someone is, how long they've been working somewhere, how much they make, and the job market. Judges tell us there's no rule of thumb that people get 1 month per year. Sure, there's no rule of thumb that they get 1 month per year, but on average, if someone is 45 years old, they've worked somewhere for 5 or 6 years, then their entitlements would be around 1 month per year. But if someone only speaks French, for example, and they're in Ontario, then that will be some of these factors that are considered to push someone higher in how much they would get in common law. Most importantly, the conclusion of this is make sure that everything that is drafted as clearly as possible, is vetted by people who know what they're doing, and cannot be interpreted in any other way than the way that you've intended it to be, and it doesn't fail the Employment Standards Act. Other than that, you're perfectly allowed to limit the entitlements of employees to the absolute minimums, provided you clear up any ambiguity, you don't contravene the Employment Standards Act. Moving on, we'll be talking about how these mistakes happen. I cannot stress this enough, but do not use ChatGPT. Don't use ChatGPT. Chris, can we use Gemini? Don't use Gemini. Don't use any AI software that will help you draft an employment agreement. In fact, don't even use any template that has been used for 2 or 3 years. The law often changes, and it changes in a way that it renders employment agreements unenforceable. There's a way to resolve that, and it is to have the employment agreements treated as a living document, meaning you have to always take care of it, you have to always examine it if it's still enforceable, and it is to roll out these employment agreements at specific times. So at the end of the year, you give someone a raise, you're absolutely within your right to subject that raise or to have the raise subject to an employee signing this new agreement. So Whenever there's a raise, whenever someone goes up or gets promoted in their position, for example, you hire an admin assistant, and next thing you know, now he or she is managing the entire office. Now they're an office manager. These changes in the duties of the employee actually mean that the old employment agreement is no longer enforceable, and it's a new employment agreement that needs to be looked at. And if it's a new agreement that needs to be looked at, and you've made these changes without offering this new contract, and without having this new contract signed, then there's no agreement to rely on. And if there's no agreement to rely on, there's no termination clause to rely on, meaning someone will get common law notice versus getting their ESA entitlement. So changing in role, compensation, reporting structure, any significant part of what an employee does may require a new employment agreement to be rolled out. Sure, there are the risks that these employees don't like this new agreement, but then there are ways to resolve that, whether it's working notice, whether it's giving them, well, you have to give them consideration when you give them a new agreement. This, simply put, is the employee has to get a new benefit for signing this agreement. And that's often one-time payment of $100 or a gift card, an extra vacation day, anything of value to an employee that they get for signing that agreement makes the employment agreement enforceable. Next, Clifford will be jumping into cases that all employment lawyers sort of know dearly, and we talk about them often. So without further ado, Clifford, please take over.
Thank you very much, Chris. We will see in these cases to follow the actual living embodiment of what Chris was mentioning about termination clauses and how they actually play out. So the first case we're going to focus on is the Wakesdale case, and this case really signaled a fundamental shift in how the courts approach these kinds of employment disputes. So in this particular case, what I want you guys to focus on is the fact that the court did not look at the without cause and the with cause clauses in the contract in isolation. They looked at them in conjunction and in relation to one another. And that had very, very significant implications for the employer because the courts ultimately determined that because one of the clauses was not enforceable, both of them fell. So what's interesting about this case is the employer, in fact, admitted that the four-clause clause violated the Employment Standards Act. And they tried to make the argument that it's irrelevant because the employee was dismissed without cause. The court rejected that argument because a problematic four-cause clause taints the entire contract. So this really signaled a fundamental shift in how the courts are looking at employment contracts. As Chris had mentioned, template discipline is extremely important. So assume that your contracts and your templates that are stale, multiple years old, they're probably not valid. The courts are always issuing new decisions, and unless you're in tune with that, you won't know, which opens up the company to potential liability. So always assume that the cause language in your employment agreement is going to be the most dangerous part of the contract because cause can be used to potentially deny entitlements upon termination. One other thing, and Chris mentioned this in his initial comments, this contract in this case actually had a severability clause, which allows unenforceable or illegal sections of a contract to be removed. It's kind of like a saving clause. And the court said a severability clause in this case cannot save a termination clause that violated the ESA, the Employment Standards Act. So again, for employers, assume that the courts are going to be interpreting these things against you. If there's even a sliver of hope that it's possible, assume it's going to be interpreted against you. The next case I want to discuss is along the same line of reasoning, and this is Dufault, another very, very significant case. And in this case, the courts are increasingly sensitive to clauses that allow termination during ESA protected leave. So the question here was a question of at any time language. Now, it's trite to say that you can't terminate an employee at any time, yet that was the language that was actually in this case. So again, employers need to ensure that the drafting and the language of the contract is in alignment with the Employment Standards Act, and it's using simplified language because when an employee goes on leave, and depending on how that affects the company, that could be a potential litigation trigger. We see it all the time, people running into issues with their employer while they're off on leave, whatever kind of leave it may be. So again, the safest strategy, and this is all about preventative measures, it's not about reactive, it's about being proactive, is draining the contract of any language that could be interpreted as giving the employer absolute control. That is not something that exists in Ontario. It exists in other jurisdictions, and I'm going to talk about that in a different case in a moment. But get rid of that language that makes it appear, even on its face, that the employer is holding essentially absolute power and control. One other thing that was very interesting in this case is even if the employer followed the ESA at the time of termination, the clause is still void if the contract itself breaches the ESA when signed. So again, the repair is what you want to avoid if you're an employer. You want to ensure that the contract is going to hold up. You don't want to have that fight or make that argument in front of a judge, in front of a court, because by that point, it's potentially too late. So if you take one thing from this case, it's compliance later cannot repair an earlier illegal clause. So be out ahead of it. It's the best way to protect yourself and your company. The next case I want to cite is a case our office actually argued and was successful on, and it's currently going before the Court of Appeal, I believe, in the next couple of months. There are a number of interveners, friends of the court, that are on this case because the implications of it are very significant for both employers and employees. But this case follows along the same lines as Dufault and as Wakesdale, and in the sense that employers should understand courts prioritize enforceability over employer convenience. So without question, it puts an onus on the employer to ensure that the contract is enforceable, but that's just the way that the courts are going. It's a clear indication from the courts, and in our last webinar, we talked about how that's affected the legislature and the laws that have been passed to ensure things like transparency or whatnot. So we're seeing a shift both at the jurisprudential level and the legislative level towards more protections for employees. So again, the case reinforces the termination clauses must be drafted to avoid any plausible ESA conflict. It's a really low bar to entry. So that's something that employers really need to be cognizant of. And intent is irrelevant. This is something else. I often see my clients say, well, I didn't mean to deprive them of their entitlements, or I didn't mean to draft a contract that was not enforceable, Cliff. And I say, it doesn't matter. The only question is one of enforceability, not whether it was done with ill intent or malice, or whether it was prepared with goodwill or with the best interest of the employee in mind. All the courts want to know, is it going to hold up to judicial scrutiny? And again, that's not a position that you want to find yourself or your company in, having to defend the enforceability of this contract. So something else that was interesting in this case is incorporating ESA compliant wording does not save an otherwise illegal clause. So we were talking about the severability clause, putting in kind of blanket clauses saying we will comply with the ESA at the time of termination. It doesn't save you. It's not sufficient to cure the problem created in this case with the at any time wording. So again, you don't want to be playing defense. You want to be playing offense in these situations and ensuring that your contract, if in the instant it is challenged by an employee, it's going to be able to hold up against judicial scrutiny because it's clear, it's unambiguous, and it aligns entirely and perfectly with the Employment Standards Act. So keep an eye out. Our office will be arguing this in the next couple of months at the Court of Appeal. And regardless of how that shakes out, it's going to have major, major implications for all employees and employers in the province. The next case I would like to discuss is the Boyle versus Salesforce case. This is an interesting case because there's extra jurisdictional issues that factored into this case. So as Chris mentioned, complexity is going to be your enemy when you're preparing these contracts. The more complexity, the more layered, the higher the risk. The more chance there is for a judge to find even a kernel of ambiguity that they will use on to pull and potentially bring down the entire agreement. That's what a lawyer is going to do if on behalf of a former employee, if they sense ambiguity. And again, these are not games that you want to be playing with the courts or with opposing counsel. So prioritizing drafting that is clear enough that HR can apply it consistently. And again, going back to what Chris mentioned, these are parts in the company that have to work together to ensure that what's in the contract is being actually applied in practical reality on a day-to-day basis. And the termination practices have to align with the contract as well. So there has to be uniformity across the board in the company. Now, going back to what I mentioned at the beginning of this case, something I've seen when dealing both with lawyer clients as well as employees is oftentimes an employee will be working for a company that has offices all around the world. And in those jurisdictions, their laws are very different than ours. So Chris mentioned template discipline. When you're bringing in templates from extra jurisdictional areas, the United States, for instance, you will find a lot of times that the elements of those contracts, the elements of those templates are not in alignment with the Employment Standards Act. They're not in alignment with the relevant case law. So in this particular case of Boyle, the clause included terms from Salesforce's global employment documents, creating ambiguity as to what actually applied in Ontario. So this is another added layer of complexity that you want to be able to remove. You don't want templates, precedents, standards from other jurisdictions attempting to be used on your Ontario employees, because the courts are going to zero in on that. And they're going to use it to potentially find ambiguity. And even if you're not in front of a judge, you may be dealing with an aggressive plaintiff lawyer who points out the fact that a contract has language that is only applicable in Arkansas, or has language that is only applicable in France. And therefore, how can it be applicable in Ontario? Creating an ambiguity that they're going to pounce on. And again, you guys will be playing defense. And the one thing you want to be doing with respect to these contracts is playing offense. And Chris is going to talk some more about that after we run through the cases, what you guys can do proactively to ensure that this is not the case. Moving on. Wigdor versus Facebook. This is a relatively recent case. And this, Chris mentioned the phrase living document. All of the documents in your possession that the company is using with respect to employees, they all have to align. There has to be internal consistency between the contract, between resignation terms, bonuses, policy documents, human rights, human resources, all these kinds of things. So the contract itself is not discrete, it's not acute. It needs to be viewed and analyzed through other documents to ensure uniformity, consistency. The bigger a company gets, the more arms it has, the more documents are created by separate departments. How can one ensure that these documents, which are all related to one another, are in uniformity or in consistency with one another? That's something that the courts and again the legislatures have been putting the onus on the employer to do so. It is onerous. It is sometimes a huge undertaking, but again, you'd rather be doing this now than dealing with one or multiple employees challenging you post facto. So the takeaway here is all sections of the contract and related employment documentation must speak the same language, so to speak. Really, we're talking about internal consistencies. So it's a very tedious task, but the diligence is necessary to ensure that you're not finding yourself behind potential liabilities for a poorly drafted or ambiguous contract. Moving on. The Raman v. Cannon design, this is a very interesting case because in this case, the employer attempted to use the sophistication of the employee essentially as a defense. The court roundly rejected that. And in fact, it's very much the opposite. The senior employees, the more sophisticated and longer tenured, they carry greater financial exposure. So when a court is looking at this in terms of what might this person be entitled to, they're going to amplify, they're going to enhance potential entitlements because of their seniority. So what is also really interesting about this case, and it may sound counterintuitive when I discuss it, is this employee in question was not only sophisticated, she had actually obtained independent legal advice known as ILA prior to executing her contract. Now, one might think, well, that sounds really strange, Cliff. Sophisticated, they went and they got independent legal advice, they signed the contract. How can it possibly be ruled against the employer? Again, the courts are bending over backwards to accommodate employees. So the level of sophistication, even independent legal advice, is not sufficient to ensure that you'll be able to use that defense when the employment contract is challenged. Again, the onus is very heavy on the employer, but these are not defenses that you'll be able to proffer. The courts are not interested in the sophistication of an employee or whether they got independent legal advice or these kinds of things. They want to know that the contract was drafted in consistency with the Employment Standards Act, in consistency with the relevant case law, and they're going to find a way to make sure that happens, oftentimes to the detriment of the employer.
Thanks, Cliff. Common mistakes employers must eliminate. Honestly, just use templates. Many companies get templates and then they take them home or to the office and they change them. Well, don't do that. You just defeated the purpose of having a template that is properly vetted. And it's often really small words that make a big difference. For example, terminating someone and saying at the end, we will give them all their salary for the duration of the notice period. Well, that's different than wages. Salary is different than wages in the court's eyes because wages include their vacation pay, includes their pay if they have anything accrued. Bonuses, just don't change documents when they're given to you. Use the templates that are given to you and renew the templates once a year. An ounce of prevention is worth more than a pound of cure, or whatever the saying, however the saying goes. The amount of money you spend on a standardized template that you could use with all your employees is just nothing in comparison with someone saying, well, instead of 2 weeks of pay, you owe me 3 months or 4 months or 5 months or 6 months of pay. And often, short-term employees still get significant common law damages if the contract's unenforceable. So treat it as compliance and treat it as part of a yearly review that you do, subject to approvals and controlling the version that you give out. I would say don't give an offer of employment that is not an employment agreement, because offers of employment offer the position itself and a lot of the time outline a lot of the issues that are or supposed to be in the employment agreement. So if there's ever contradiction between those two, it will be used against you. And HR folks should be trained more and more on the legal side of things as much as possible. That's just to avoid legal fees, really, and to avoid having to go to a lawyer every time. So often we will help teams of managers to avoid human rights issues by training the managers of how to identify human rights issues, how to deal with them. And same with HR folks. We often help in explaining similar webinars to this one. It may be a bit more detailed in that how the drafting and the wording itself should be, and just to have sort of red flags screen themselves out at you to make things a bit easier. So the following slide is about enforceable termination clauses. What should they contain? They should contain what you want them to contain, less anything that is not necessary to contain. So that means the situation of terminating someone without cause, meaning through no fault of their own, what would that look like and what their entitlements would be? And what would their entitlements not include? So not including common law, not including equity, for example. And they should include the situations where someone is terminated for cause, meaning what happens if someone steals money or they siphon clients from one company to their own company that they have on the side, for example. These are reasons for just cause that should be included in a termination clause. But perhaps the most important thing to remember is that if you have a perfectly drafted termination clause and a perfectly drafted employment agreement, if you allow an employee to start before they sign the agreement and then they sign the agreement, then this contract is not enforceable. So proper training of when to roll out an agreement, when to provide the consideration, meaning the benefit to the employee if they sign the agreement, all those are equally as important, perhaps sometimes more important because people just don't mind them enough than the actual language in the termination clause. Following that, the high risk scenarios to pay attention to the long service employees. Long service employees tend to get a lot more than someone who just started, because the logic is if someone has worked with you for 10 years, it's going to be that much harder for them to go and get another job that is one, comparable in pay, comparable in experience, and they may just simply not be able to land something because their skill set potentially could be that much more ingrained in the previous company's culture. So they may need a bit more training versus someone straight out of school. So in addition to employees who are long tenured, employees who have any human rights issues tend to be the riskiest of all. And human rights issues kick in as soon as someone starts working. So if you hire someone and on the next day, let's pretend female, and she says, I'm pregnant. And if you decide to fire her right away, it doesn't matter that she's still on her probation period. That is a human rights violation because at least a part of your decision to terminate her, and it doesn't have to be the entire part, just a part of the reason to terminate her was due to pregnancy. then that will open you up to liabilities that are far exceeding what the common law would be. For human rights, briefly put, applicants will get general damages, and that's anywhere between $5,000 and $20,000 of non-taxable money. And on top of that, bigger hurting part, or the more dangerous part, is all their lost wages from the date of termination until the date of a hearing or the date that they get another comparable job. So rolling them out, but rolling them out on the right people and being mindful of the nuances between these employees will help you avoid a lot of financial headache as well as peace of mind. And the last thing I'll bring up, which is the last bullet point on the slide, is fixed term agreements are especially dangerous. There's many instances where someone has worked somewhere for a very short period, but they have a fixed term contract for a year, and they've argued that they're entitled to the remainder of the contract, regardless of the time that you fire them. And worse than that, and I promise this is not to scare you, it's just fixed term agreements are a terrible idea. Worse than that is if someone gets another job the following month, well, Chris, they now have mitigated their damages. They're making the same amount of money they would have made with me. There are no damages. That's not the case with fixed term agreements. With fixed term agreements, people will get the remainder of the agreement regardless if they get another job and when they're terminated. The last slide is about a checklist. Make sure you review your agreements with someone you trust, someone who knows what they're doing. Don't do it with us unless you like us, but do it with someone you trust that you work with, that you know who's going to tell you these are the necessary changes versus these are just optional changes just to make it look like you're doing more work than you really have to. Make sure you trust the people that you work with, but do consult with lawyers because it will cost that much less to figure out a solution before it happens rather than to be on the receiving end of a lawsuit or a demand letter. And make sure that your managers are trained, your HR folks are trained. Again, it does not cost that much money in comparison with the potential damages that could ensue. And hopefully none of them do. That's the end of our presentation, subject to questions. It's 1 week per year that the employee has worked there. Someone who's worked for 10 years, for example, could get only 8 weeks if the company's small and doesn't have a 2.5 million payroll, or could get 8 weeks for termination pay plus 10 weeks for severance pay, so 18 weeks. And again, that is the absolute minimum that they would be entitled to. So one little trick to keep in mind is if you have the contract reviewed, the existing contract reviewed, if you find that it is not enforceable, and there's a huge chance, for example, it's not enforceable, then you may want to offer the absolute minimums, but then you add onto it a week or two in exchange for a signed release. A full and final release is essentially the document that will stop an employee from suing you if they sign it and if they accept that extra pay. So thank you for listening to us. Hopefully you learned from this. Our next topic will be March 4th about AI in the workplace. I've warned you not to use AI at all to draft agreements, but there are ways that AI can be used to avoid liability and be that much more prepared when you consult with someone. So hope to see you there. And thank you again for joining us.